Honorable Sadiq, please.
Sir, what is happening in Safana is all over northern Nigeria and is even negotiating more in the northeast third part of Nigeria. It is or people from those areas in the northwest in Adamawa State. Some of the victims are moving, and some of those who unleash terror on them are also moving. So what is happening is that both those who are unleashing the terror and the people that are terrorized are all people that we can call now disabled or vulnerable people. They are all vulnerable, both the victims and those who are victimizing them. So, sir, I hope this House will take a more holistic look at this situation so that we can, as a people of Nigeria, find a way of solving the problem once for all. Thank you, Mr. Speaker.
Honorable Sadiq, please.
My name is Honorable Sadiq Ibrahim. I represent Fufore Song Federal Constituency from Adamawa State. Mr. Speaker, Honorable Osai has given us a very concise report of what he wants us to do regarding these 4 sections that he pointed out. I am in support of some, but I'm constrained to oppose the amendment of some. In the first instance, Mr. Speaker, he started with the provision of Section 293 of the Companies and Allied Matters Act, where he proposed a penalty of 50,000 naira for failure to appoint a secretary by a private company, or 500,000 naira for a failure by a public limited liability company when it carries out business without a secretary for the period of 6 months. Mr. Speaker, I'm constrained to oppose that proposal because subsection 2 of that section 293 is adequate for our purposes. With your kind permission, Mr. Speaker, I read subsection 2. It says anything required or authorized to be done by the secretary may, if the office is vacant or there is for any other reason no secretary capable of acting, be done by or of any assistant or deputy secretary, or if there is no assistant or deputy secretary capable of acting, it can be done by or of any officer of the company authorized generally or specifically in that behalf by the directors. So I do not see any reason why or where a company should be penalized for not appointing a secretary for a period of 6 months. Because whatever the secretary will do has been covered by the assistant or deputy secretary or assistant or deputy capable of acting or any officer of the company authorized generally or specifically in that behalf by the directors. So to say that you will penalize a company for 500,000 naira for carrying out business for 6 months without a secretary, when in fact a deputy secretary can do, or one of the directors can do, I think is to me verbose. Out of the 4 sections that he pointed out, that 2 I agree that they should be amended, they are good for us and for the business and registration in this country. But 2, Mr. Speaker, I oppose because they do not add any value to the amendment he wants us to do. And I wonder if I could mention the ones that I feel he is on all fours. It is right for us to amend. For this, Mr. Speaker, I'm very much in support because companies limited by guarantees are not supposed to be vehicles for making profit. So to say that one will participate in sharing divisible profit of the company if it is authorized by the memo or articles of that company I think is clearly not acceptable, and it is not the intent of the makers of that legislation. Mr. Speaker, I remember clearly this section was not in the 1990 Principal Act. It was an amendment that was done later following what happened in the Nigeria Stock Exchange. There was a time the Nigeria Stock Exchange, when they made profit, Mr. Speaker, they were buying wristwatches and sponsoring boat regattas, and then they were sponsoring boat rides for their own members. That was making profit and then making use of that profit. That is the reason why the first amendment was done, and I'm in support of generally that this amendment be carried out, that no company limited by guarantee should have any provision of dividing or division of any profit they may have made in the course of their operation. The third section, Mr. Speaker, is section 26.5, where Mr. Osai sought to make the Attorney General responsible and responsive. Where, Mr. Speaker, members of like minds agree to form a company limited by guarantee. You cannot register a company limited by guarantee in Nigeria without the fiat of the Attorney General of the Federation. Where you seek the fiat to so register, this act does not give the applicant any latitude. If the Attorney General feels that you should not register, you cannot register, and he has no responsibility to tell you why he has rejected your application. For this, I agree with the proposal that the time limit of 2 months be given, but I feel 2 months, Mr. Speaker, is too short, because members of company limited by guarantee may be people who may hide under the facade of that guarantee to do business and avoid tax. In that respect, I believe the Attorney General or his office needs a time much more than 2 months to investigate who are behind that company. Therefore, I propose, Mr. Speaker, that 6 months be given as a time limit within which the Attorney General must respond. And, Mr. Speaker, I would want to add, because we have to hedge against what happens if the Attorney General does not give approval. I'm suggesting, Mr. Speaker, that we will add another subsection, which will be, you have added subsection 5. I want to add another subsection 6 that will say that where the Attorney General denies authorization pursuant to the subsection 5 you are suggesting, Mr. Osai, then he shall, within 30 days of the receipt of the application for authorization, send to the applicant a notice of the denial, giving him grounds under which he is denying that registration. And finally, Mr. Speaker, regarding section 30, subsection 1 and 2, Mr. Osai has suggested that we should put incorporated trustees after the word company in those sections. I'm opposed to that, because it is common knowledge that Companies and Allied Matters Act, I beg your pardon, is divided into parts. Part A is for limited liability companies. Part B covers business names, and Part C is for incorporated trustees. So to bring incorporated trustees on a chapter that concerns private limited liability companies, I think to me is doing injustice to the compartmentalization of the types of businesses that is sought to be covered by those sections as divided in the chapters. Mr. Speaker, I rest my case. Thank you very much for giving me this opportunity.
And the question is that the bill be now read a second time. Those in favor of the motion say aye. Aye. Those against it say nay. The ayes have it. Honorable Sadiq, please.
Mr. Speaker, in lending my voice for the support of this motion, for the reasons of, apart from instituting orderliness and orderly conduct in the FCT, the project would definitely bring revenue generation, and definitely, Mr. Speaker, it provides employment. However, Mr. Speaker, I have looked at the judgment of the FCT High Court that invalidated the regulation that was made by the FCTA in 2005. Two reasons were provided by the court, among others, Mr. Speaker, that the persons that took the FCTA to court were said to have been made to pay a fine without trial and conviction by a court of law, and that the powers of the FCTA unilaterally to impound a vehicle for alleged breach of that regulation was wrong. I have the fear, Mr. Speaker, that if you have to convict a person who momentarily parked beside a road to go into a shop and pick one or two things, come back and pick his car, and then you ask that he must be convicted by a court of law and made to pay a fine, the incongruous nature of our courts and the slow way of obtaining justice in this country, we may, in the process of making right the wrongs of parking without order, also bring a lot of vehicles in the premises that we don't want, like we have in the VIO offices and we have in police stations. So these are some of the safeguards that I would suggest, Mr. Speaker, when this law is brought, for this House to take into consideration, so that we don't create problems by trying to solve one. Thank you, Mr. Speaker.
Aye. Those against it say nay. Nay. What? The nays have it. So we have heard that this dam is all important. If not because located happens to be Honorable Sadiq's village. So I want to recognize him to say a word before I put the question. Honorable Sadiq, please.
I represent the people of fufore and Song from Adamawa State. With humility and respect, Mr. Speaker, I rise to shed more light on this dam. Mr. Speaker, I knew about this since the time I was in primary school in 1977. At that time, Mr. Speaker, we saw some white men that came to the village measuring and marking some areas at the bank of the river where my village, Dasin, Hausa, is situated. Mr. Speaker, since that time, I have been familiar with the area where the Lagdo Dam is built in Cameroon, because my area borders the northern Cameroon. And Mr. Speaker, I'm aware that since 1982, the dam in Cameroon commenced construction in 1977 and was completed in 1982. Mr. Speaker, in 1980, Nigeria and Cameroonian officials held series of meetings, and an agreement was reached between Nigeria and Cameroon that the buffer zone will be built at Dasin, Hausa, to serve